Board staff, Assistant Attorney General Eisentraut, Stanifer, are you ready to proceed?
Yes, Your Honor.
Board members ready? Okay.
Right here?
I think so.
All right, we are now back on the record. Took about a 2-hour break due to the unavailability of Legislative Ethics Board Member Roberts, who is also participating via Zoom at this time. We had stopped in the middle of Representative Simmons' testimony. At this point, Mr. McKinley, you can resume with your direct examination of your witness.
Okay, thank you, Your Honor. Tarra, I want to talk to you about your donation to AEJG and Antoine Coleman's employment there. Mm-hmm. Can you explain your relationship with Anthony Powers?
Yes, I met Anthony, he got out of prison maybe around 2019. He got clemency from Governor Inslee, and he had a story of redemption, and we became friends through that community, which I'm a part of. We over the years became closer. We had spoken on several conferences together. At one time, we actually formed an organization together. It was a political action committee, the Real Justice Washington PAC. We were board members where we were trying to help elect other formerly incarcerated people or support formerly incarcerated people who might want to run for office. Couldn't necessarily find any formerly incarcerated people, but supported candidates who would be favorable to criminal justice reform measures. That was probably in 2022. In 2023, I will say that I had gone through a really difficult experience where I was wrongfully terminated from the organization that I had founded, and Anthony and I got really close around that time. That was August of 2023. In September of 2023, I had an event called Freedom. It was a Freedom Day. It was when Senator Hansen had represented me at the court to clear my entire criminal history from the New Hope Act, which he passed. Him and Representative Morgan Irwin had passed that bill together in 2019, and I became eligible in 2023 to vacate my entire criminal history. And so Senator Hansen represented me, and the prosecutor had agreed to that, and we had a big celebration afterwards, and Anthony came to that celebration, and we had been talking a lot on the phone around that time, and also through text messages, and he was supporting me through the separation from my prior organization.
Okay, so it was safe to say you were very close personal friends by that point?
I believed so. We talked several times a week, if not almost daily.
Okay, and did you talk to him about his organization, about AEJG?
Yeah, so that was actually after I had already sponsored the first proviso in 2023. That happened in January 2023, and I believe that was a long session. So that was done in April of 2023. And then in the fall of 2023, when I was separating from my organization, he and I were talking a lot, and he told me that he also had concerns that he was going to be ousted from his organization that he founded. And the reason he felt that or had concern is because he felt that Kim Gordon, who brought this complaint, was trying to take over his work. So he felt that she was on the board, but she was also his employee. And he was concerned, and so I started giving him advice on that he should get an employment contract in place to protect himself. And this is when I started to really become more interested in supporting him to make sure he never went through the same kind of pain that I did with my organization.
Okay, and did you have lunch with him in December 15th of 2023?
Yes, I did.
Can you tell me the details about that meeting?
Yeah, so that was, I remember that morning I had just gotten off of the airplane from coming from Washington, D.C., where I had visited Antoine, who I had met in November. I had met Antoine in November at a conference in New Orleans. And then after that, I went to go see him. He lived in Washington, D.C., and that day I got off the airplane in SeaTac, and Anthony Powers and I were texting and getting together for lunch when I was on my way home, and we met in Puyallup, where he lived, for lunch, and it was a barbecue restaurant.
And were you meeting him in a personal capacity or a legislative capacity? And could you explain the details of why it was one and not the other?
Yeah, I was definitely meeting him in my personal capacity. We texted each other on our personal cell phones. He did not make an appointment through my legislative office. Generally, when I'm talking, the way I separate my roles and the way I've been trained is that when I am in my legislative capacity, I can get my mileage reimbursed, and I do. If I go meet somebody right from the state, it's on my legislative calendar, not my personal calendar. And he would have, if it was in my legislative role and we were talking about legislative work, he would have made an appointment with me through my legislative assistant and put on my legislative calendar. Sometimes I will make the appointment if I'm talking to somebody, but I will put it on my legislative calendar. And this was, I can't remember the day of the week. I think it might have been a Friday, maybe. But I definitely had just gotten off the airplane. We were texting each other while I was in DC and made the appointment to go have lunch as friends.
Okay, and did you talk to him at all about your relationship with Antoine at that time?
I did. I told him, I mean, it was kind of newsworthy because I've been single for a very long time. So, and I considered him my very close friend and like my brother. And also him and Antoine had a lot of personal similarities. They both had been incarcerated from very young age for a very long time. They both were Black. They both were Muslim. They both worked in criminal justice work. And I wanted to talk to him about it. I was, kind of excited I met somebody I liked, and also asking him for advice and things.
Okay, so when Mr. Powers testified that prior to hiring Antoine, he didn't understand that you had a relationship with Antoine, was he telling the truth?
He was not.
Okay. And did you discuss Antoine at that meeting?
I did.
And what was the context that you discussed Antoine with Mr. Powers?
Well, it was kind of like two conversations happening at the same time. I was telling him about Antoine, but we were also talking about his organization and his fears about Kim Gordon and the fact that he wanted to hire more formerly incarcerated people and more people of color. And so at the same time, I said, oh, well, maybe, you could talk to Antoine about working with you.
Okay, and how to elaborate on that conversation?
Well, he said that he would love to talk to Antoine about working with him, but he didn't have any money to hire him. And that's when I offered, I said, well, if you do talk to him and you wanted to hire him, I could make a donation out of my campaign surplus to help you guys.
So would you say it was more a case of your conditioning the donation on him hiring Antoine, or more a situation where he was conditioning hiring Antoine on getting the donation?
Objection leading.
Your response, Mr. McKinley?
There are two equally plausible answers. I don't see how I've suggested one or the other.
I'll overrule the objection. There was a conjunctive or in there that was not suggestive of either of those two options. You can repeat your question if necessary for the witness.
Would you say your offer to donate $10,000 to AEJG, was it more a question of, if you hire Antoine, then I will donate $10,000, or I will donate $10,000 if you hire Antoine?
I would say it was the latter. It was that he was going to talk to him, interview him, see if he liked him first. I never said he had to hire him. I just said if that's something that you wanted to do, I could donate the money if there was that need.
Okay. Is Anthony your constituent?
No.
Did he ultimately interview and hire Antoine?
He did.
And did you ultimately make a $10,000 donation when he did?
I did.
Were there any strings attached to that donation?
No.
Could they have kept the money?
Yes.
Could they have fired Antoine?
Yes.
Did you have any recourse to get the money back if they kept the money and fired Antoine?
No.
Okay. Did Anthony ask you to become more involved in the organization at that time?
Yes, he did. During that fall period, from the time I saw him at my freedom celebration, September 8th of 2023, until that lunch on December 15th, I had been talking to him regularly about giving him advice around protecting himself as the founder of his organization and getting an employment contract, talking to him about, potential other ways to grow his organization with foundations, with private donors, things like that, because that's something that I had done when I founded my organization. And I was also kind of grieving at the time of losing my position with my organization and not wanting him to go through that. So I was talking to him regularly about his organization and about his fears around Miss Gordon.
Could you elaborate about his fears about Miss Gordon?
Yeah, he was concerned that she was going to oust him out of his organization.
Okay. Did Anthony advise you about your relationship with Antoine?
Yes.
What was the nature of that advice?
Oh, to give it time, be patient. That for men who serve a very long time in prison, it's very hard for them to get into any kind of relationship. And so it was, that he's going to go through a period of time. He would talk to me about his reentry, what all that's going to entail. And I mean, I know those things from my own perspective, but I don't know those things from, a person like Antoine or Anthony. And so he would give me advice on those types of things.
Okay, I'm going to direct your attention to page 284 of, I believe, Exhibit F. Can you identify that document for the court?
Yes, it's a text message I sent to Anthony.
And what are you telling Anthony in that text message?
I was telling him to work directly with Antoine about, the job, and that Antoine and I were hoping to be in New Orleans together until January 4th.
So at that point, he'd made the decision to hire Antoine, but Antoine had not yet started?
Yeah, I believe this text message was on December 21st.
Okay, and you were telling him that you were going to travel to New Orleans with Mr. Coleman?
Yeah, so I was going for the Christmas holiday with my kids, and then my kids and I were we were going on a cruise, and we were getting off of the cruise on December 31st, and Antoine was planning to come meet me in New Orleans for New Year's Eve.
Okay. So I want to circle back a little bit to your maintaining relationships as in your legislative role and in your personal role. Are you familiar with other legislators who are in relationships?
Yes, my understanding from the time I got elected is that we are a part-time citizen legislature, and that it is, we need to maintain clarity around the role that we are in, but we are still expected to have outside employment. We're still expected to have outside personal relationships, hobbies, organizations that we are involved in, and it's just important to be clear about which role we are in at the time, and those are things that, I mean, we have legislators that are married to lobbyists, that they actually have joint passions and work together. But then, when they're home, they're not considered in a legislator lobbyist relationship. We have all kinds of different relationships that we have to manage, multiple relationships at once. And that is on us as legislators to know those rules and to make sure that we are clear. And the ways that I have adopted that is by making sure that people know which role I'm in at a certain time. And it tends to be if you have a legislative nexus that you're talking about, or legislative nexus is something that we work on in our role as a legislator. And also signs can be, am I wearing my name tag? And this also bleeds into using state resources for campaign purposes. Like you would never want to wear your official name tag to, a campaign event. That would be a violation. We don't use state resources or our state laptop for certain activities. We have to have our legislative calendar, our personal calendar, separated. And we also generally have two different cell phones, a legislative cell phone, a personal cell phone. Now that gets tricky because I don't have a legislative cell phone anymore because I wasn't answering that one. So I have one, and so I have to be extra cautious on my personal cell phone. But there are so many different ways. For example, I said if I go to a meeting and I'm talking about legislation, I can bill the state for my mileage reimbursement. But generally, campaign stuff is absolutely, that's a violation if you intermingle campaign stuff. And so campaign surplus funds are definitely not something that is legislative related because people have that. They don't have to be a legislator to have that. People that don't win have that. And so I felt donating out of my campaign surplus to my friend to help his organization and help another friend. And I was there not talking about legislation, that I didn't understand how that was in my role as a legislator.
Okay, and that brings us to the $40,000 that you did donate an additional $40,000 to AEJG, is that correct?
I attempted to.
Okay, and what was the need for that money?
Well, the need for that money is that Anthony told me that they owed the IRS a bunch of money because they hadn't been paying taxes. I believe it's because they didn't understand that they had to withhold certain funds from when they became employees. And so they had a large tax bill. And what was happening then is that their other staff, not Antoine, but their other staff were not going to be able to work for the rest of the fiscal year because they had to pay the IRS.
So what was your understanding that how Anthony was going to use the money?
To pay his other staff because he had to pay the IRS, or the IRS, it was the one or the other. It was for general operations to support the entire team until they could raise some more money. And I was trying to help them raise money with private foundations as well.
Ms. Gordon had indicated in her testimony that you conditioned the money as being spent on Antoine. Was she being truthful when she testified to that?
She was not. May I clarify?
Sure.
I don't know if it was that she wasn't being truthful. I believe that she didn't know because her and I didn't have any firsthand conversations about any of this. I only talked to Anthony about these things.
Okay, so do you know where she was getting her information?
I don't know for sure, but I assume that she was talking to Anthony.
Okay. And when you offered to donate the $40,000 and gave Anthony the check, did you have any conditions on it?
I didn't give Anthony the check. I ordered it from my campaign treasurer who mailed it. And I've come to learn that it got mailed to Kim Gordon's law firm. I believe that's what they were using as their mailing address. But no, there was no conditions on it.
Okay. And that extended to, there were no verbal conditions, no written conditions?
No, none at all.
Okay. Did you ever ask them to return any of those funds?
No, no, I did not. I was surprised when they returned the $10,000 for sure. I never even expected that.
And how was it explained to you by Anthony? The decision to return the money to you?
The decision, he told me that they went to a board meeting and that Kim Gordon had brought up she had concerns because she saw a Facebook post about Antoine and I. And she told that to the board, and he said that he wasn't, he didn't agree with that, but the way she brought it up made everybody nervous, and then that's why they ended up terminating Antoine and returning the money.
Okay. Did you have any role in AEJG?
No official role, just Anthony's friend and trying to support him and look out for him to ensure that he didn't lose the work that he had built.
Were you helping to organize a retreat?
I was.
Can you tell us about that?
So Anthony wanted to have a board retreat, and the goal of that was going to be to get him an employment contract and to also get Kim off of the board. Her being an employee and being a board member made him feel like he couldn't actually lead the organization he founded because she was both his employee and his boss. And I was just telling them general best practices from my experience of managing and growing a nonprofit and making mistakes and failing and learning, that it is general best practices that your staff are not on the board. And I've advised several nonprofits around this since then, because conflicts can come up where you might not even foresee it until it happens. And so he wanted to eventually get to a board retreat, but he felt that we should have a staff retreat first, because his staff were kind of new, coming together, hadn't spent a lot of time together, and getting them on the same page. And also the board members, some of the board members lived out of state, and it was going to take a long time for them to be able to convene a board retreat. So I said I would offer to facilitate a staff retreat first, and then I would offer to facilitate a board retreat. I have done this for other nonprofits, and just wanted him to be successful.
And your interactions with AEJG, did you ever have the occasion to interact with Kim Gordon personally, one-on-one?
No.
How would you describe your relationship with her at that time then?
At that time, I knew I had met Kim before. We had served on the Sentencing Guidelines Commission before, and I had ran into her a couple of times she's a criminal defense lawyer, so I knew her from that kind of like convenings, maybe like conferences or something, but I did not have her personal cell phone number. We didn't talk, we didn't text, we didn't have phone calls, we didn't have individual conversations at all.
So when Kim Gordon testified about various actions and activities that you undertook, was she speaking from firsthand knowledge?
No. Outside of, it was either 3 or 4 staff meetings that I attended to listen and get more information about the organization and the work in order to prepare for facilitating their staff retreat. That was the only times I had interacted with Kim in any way since, I would say, at least a year.
Okay, and when Anthony emailed you a letter to tell you that he was returning the $10,000, I'm going to turn us to Exhibit 2, page 10.
Exhibit 2. In there. Okay. It's, I think there's the board staff. Exhibits. Okay.
Mr. McKinley, Exhibit 2, page 10, is that correct?
I believe so. And do you recognize this email?
Yes.
And what's the significance of this with respect to your maintaining separation between your legislative and personal roles?
This is an email from Anthony when he returned the $10,000 donation and sent the letter. I believe there was 2 letters, but saying that they were returning the $40,000 donation uncashed and also going to return the $10,000. The significance is that he sent it to my personal Gmail, and he writes in there, I can try to make a call in the morning. Hope your Gmail was sufficient. Let me know if you want it sent to a different address, but I thought this was the one you used for these purposes. It was very clear, and I always made it very clear, that the donation and the volunteer work that I was doing for AEJG was in my personal role. And if they ever wanted to talk to me about anything legislative related, they have to make the appointment in my legislative role. And so this was just one example of the ways that I kept those boundaries.
Okay, but there was interaction with AEJG that you undertook in your legislative role, as well as these activities that you undertook in your personal role. Is that correct?
Yes, but it was very limited in my legislative role with AEJG to the proviso that I had requested in January of 2023. And then I did not interact with them in my legislative role after the session was over in 2023 and during the interim. All of the interactions I was having with Anthony at the time were in our personal roles. Him coming to my freedom celebration, us talking about his concerns for his organization, and the dynamics with Kim being on the board and a staff member, and me volunteering and supporting him, and him hiring Antoine and me making a donation and my volunteer work. We didn't talk again about another budget proviso or anything legislative related until the 2024 session started.
If we're going to assume that you're going to have both a legislative relationship with AEG and a personal relationship with AEG and Anthony, is there anything in your mind that you could have done to keep those roles more segregated that you failed to do?
I can't think of anything. I don't know if I should have an employment contract with my friends. I mean, I have employment contracts when I have outside employment to make sure that I have those conversations from the very beginning. But since I wasn't being paid, this wasn't an employment job, it was a friendship. I didn't have a contract in writing that this is my friend, and if you want to talk to me about legislative, you go here. I just make sure that I consistently do that with my friends.
And did Anthony understand that?
Yes.
And is this email evidence in your mind that he understood it?
It is one piece of evidence.
Okay. I'd like to turn now to your employment with EEC. How do you know Sharon Navas?
I didn't remember this, but she remembered and reminded us that I met her at Senator Hansen's law firm, Sussman Godfrey, when we went there to record, I think it was a Facebook Live in maybe 2018, prior to when or after the New Hope Act passed, one of those, very close to 2018 or 2019, and that's when I met her for the first time.
And how did you hear about the job with her organization, EEC?
I believe I saw a posting, and I do remember seeing it and saying, oh, that would be a cool job, but it was full-time, and I would not be able to commit to that. And I think I jokingly responded like, oh, there's a great job, but I can't, apply for that. And then I didn't even know, but maybe like 2 months later, this was probably October of 2023. And then in December, she said, hey, do you want to get dinner? And we were not close friends. We knew each other, but not closely. And we went to dinner in December, and I did not even know at that time that she was considering me for an actual job. But that became more clear during the course of that dinner.
And ultimately, what was the result of those discussions?
She told me that she would give me a part-time job.
And I've opened your notebook to page 204 in Respondents Exhibits. I believe this is Exhibit C. Do you recognize that document?
I do.
And can you tell me what it is?
Yes. Do you want to wait till it's on the screen, or I don't know? But
Yeah, Mr. McKinley, just one moment, please.
Certainly.
And that was page 204?
204, correct.
Yeah, I just wanted to give everybody a chance to catch up.
yes, this is the job description that we created. The original job description that she had created was full-time, and this was done after this job description was developed after I sent her my prior employment contract. So we had dinner, and then we talked about this. I sent her my prior employment contract with Civil Survival, which had been approved by Jen Struess, and had the provisions in there that Jen Struess felt would protect me from any ethical violations in that role. And I actually wanted her to give me an employment contract that was similar, and she did not want to do that. So she sent this back to me.
And what were the provisions that Ms. Struess had advised you about?
The provisions that Ms. Struess was pleased with were the provisions in my employment contract that had to do with fundraising and making sure we don't ask lobbyists or lobbyist employers for any funding, and also around the I could find it on another, there's the employment contract. Yes. Oh, yes, that I can't be paid for or punished, for anything that I do in my legislative role. I can't be rewarded or punished for anything that I do in my legislative role, and I can't lobby on behalf of the organization.
Could we scroll the document on the screen down to the next page? Yeah, those last two provisions right there, Washington State Legislative Ethics Compliance and Lobbying and Fundraising Restrictions. Those are the two provisions that you're talking about?
Yes.
And you had run those by Ms. Struess as your testimony?
I ran the ones that are in my employment contract for Civil Survival that I sent to Sharon, and Sharon adopted those into here and added the confidentiality and non-disparagement agreement.
Okay. At some point during your employment, or right around that time that you gained employment, Ms. Navas had testified that she and you had a discussion where you became aware of her interest in data dashboards. Is that true?
Yes.
And can you walk us through your perception of those events?
Yes, I am not a technology person at all. And so when I learned about AEJG's dashboard, that was very new to me. I still don't know how they're built or how, they can complement each other. But in my mind, when I heard that EEC was also interested in creating a data dashboard, but it was focused on the social determinants of health, and that is a that's data that can maybe predict whether somebody would end up in prison. I did not want to see two organizations duplicating efforts. I would rather see organizations collaborating, and they didn't know each other. And so I connected Anthony Powers and Sharon Navas to talk about their work.
And Ms. Navas testified that she went off with Mr. Powers after that introduction, had numerous meetings with him and discussions with him, and then came back and spoke to you in your legislative capacity to seek a proviso. Is that?
Objection, Your Honor. Now the opposing counsel is testifying, essentially. He needs to ask a question.
Mr. McKinley, your response?
Well, I was about to ask a question, but I was interrupted.
Okay. You can go ahead and I'll overrule the objection. If you have a question, go ahead.
Can you describe your recollection of those events?
Yeah, my recollection, I don't know what conversations they had, but that they did get together and talk about their data projects. And then I know that they made an appointment with me through my legislative assistant on January 23rd. And I have, and I remember that because I remember that the appointment, not perfectly, but I did go back and look at my legislative calendar in preparation for this and have a copy of that appointment that was made on my legislative calendar for January 23rd. And that helped me remember that meeting.
And during the investigation of this complaint, did you have communication with Jennifer Struess?
Yes, I sent her a copy of that meeting.
And I would draw your attention to page 149. This is Exhibit B, page 149. That looks like an email that you sent to Ms. Struess.
Yes.
And can you tell me what you're communicating with Ms. Struess in that email?
Yes. I'll let them get it up on the screen first.
What page number?
149.
Yeah, so this email is sending Ms. Struess proof that that meeting was created in my legislative role and not any way tied to my employment
With EEC?
with EEC, yes.
Okay. And now I'm going to draw your attention to exhibit number 157, just 8 pages further. Is this also correspondence that you sent to Ms. Struess during the course of this investigation?
Yes.
And can you explain the significance of this correspondence?
Oh, yeah, because I was meeting with Anthony and Sharon that evening on Tuesday, January 23rd, 2024, in my legislative role. And I knew that that was going to be the discussion around AEJG's dashboard. And I wanted to make sure that AEJG was doing a good job and using taxpayer money in a efficient way. And so I had reached out to Christopher Stanley at AOC to inquire about their performance. And he hadn't responded yet. I believe I had reached out January 11th and just asked how they were doing, and he hadn't responded. And so I bumped it up and said, I wanted an answer. And he gave me some contract updates from Anthony at AEJG.
And this was related to the first proviso?
Yes.
So EEC was not, had nothing to do with this communication?
No, I just wanted to make sure that this was a good use of resources. and that this organization was performing adequately and up to standards.
Okay. You eventually transitioned at AEC into an independent contractor role, is that correct?
I did.
And can you tell us the events surrounding that?
Yeah, I think when I got elected to the deputy speaker role, Sharon was even more nervous of me working at EEC, and she said that I should be an independent contractor instead.
And I'm directing everyone to page 207. And we've seen this agreement before. Exhibit C, yes, correct. Is this a true and correct copy of the actual employment contract that you had with EEC at that time?
The independent contractor contract, yes, the one that began January 15th, 2025 and was supposed to go to June 30th, 2025.
And did you provide some of the edits that we see in that document?
I provided all of the edits, I believe. Sharon had sent this to me. She said it was a template that she had gotten, and I added the lobbying provisions, the not being rewarded or penalized for that, for anything in my legislative role. And then in the scope of work, I added the provisions to be clear that I was not doing anything that would be in conflict with my official duties as a legislator, and I crossed out the word legislators.
And what page is that on?
This is on page 210.
Okay.
And Sharon and I also had discussions around this as well before she accepted it and signed it. And then I believe I signed it first and then sent it to her, and she signed it. But I never got a copy that wasn't redlined like this.
Okay,
never
so
got a clean copy.
if we scroll up to the prior page, I think 209. Mm-hmm. Right there. Is that your signature on the agreement?
Yes.
And is that Sharon Navis's signature on the agreement?
Yes.
And so this agreement with the underlines and the strike-throughs was the operating agreement that you performed as a subcontractor with EEC, correct?
Yes. Yes.
Were you ever paid to lobby for EEC?
No.
Were you ever paid to get a proviso through for
No.
EEC?
No.
Were you given any bonus when the proviso went through for EEC?
Not even flowers.
Was your job as a legislator in terms of the proviso and the work that EEC wound up doing under the proviso in any way integrated with your employment, either as an employee or as a subcontractor
No.
with EEC?
No.
Did you keep your roles entirely and completely separate?
Yes.
Did you believe that you were in compliance with the Ethics Act by doing so?
Yes.
If you had believed that it would be a violation of the Ethics Act for you to get a proviso for your employer, EEC, would you have done it?
No.
Once the project started with EEC, AEG, and the Administrative Office of the Courts, did you have any involvement in that project going forward?
None at all.
When was the next time you heard about that project?
Not until Chris Stanley called me.
And you heard Chris Stanley testify, correct?
I did.
Did he testify accurately?
He did.
And how did he characterize your discussions with him about the proviso and the contract dispute?
Objection. The board can evaluate Mr. Stanley's testimony.
All right. Mr. McKinley, your response?
I think it's important that the board understand that her and Mr. Stanley agree completely about what they discussed, because that is the linchpin of one of these allegations, is that in her interaction with Mr. Stanley, she influenced him. There were only two people on the phone when they had that interaction. Mr. Stanley's already testified. I want Miss Simmons has an opportunity to defend herself and say, Chris Stanley's telling the truth. I didn't influence. I didn't advocate. I went over the proviso and the budget as I would with any constituent in my legislative role. I think she gets to defend herself.
Can I have a brief response?
Go ahead.
Now council's testifying, but beyond that, it's one thing to ask specific questions about Mr. Stanley's testimonies. Another thing to just ask a general question: was this person, telling the truth, which he's done also repeatedly? I'll rest there.
Okay. I will affirm the objection in part. I will allow you to ask questions of your witness, Mr. McKinley, in regard to statements a witness who has testified may have made, but for the overall truthfulness and veracity of witnesses, that's something as the triers of fact, this board will have to decide, going back and reviewing the testimony. But if you want to ask your client questions in specific instances of statements made, you're welcome to do that.
Thank you, Your Honor. Was anyone else present when you had discussions with Chris Stanley about EEC and the proviso?
No, we just had a very short phone call. I can't remember the exact date, but it was during budget week, I will say, because I'm not on a budget committee, during the 2025 session, because I wasn't in Olympia. He had emailed me and asked if he could talk to me that day. And he marked the email to me with high importance. And he wanted to talk about the project, the data dashboard project, the proviso. And so I remember making time to talk to him, even though I was technically off, even though it was session, because I'm not on a budget committee, so I had a short little holiday.
At the time that you had this conversation with Mr. Stanley, at the beginning of the conversation, was he aware that you were employed at EEC?
He wasn't. I actually disclosed that to him because I was concerned about being close to this issue at all. So I said, hey, I just want to let you know that I used to work at EEC. And he was like, oh, and he didn't say anything about that.
You used to work at EEC?
Yes. Mm-hmm.
So had your subcontracted ended at that time?
No, I was still an independent contractor, but I didn't even know what he wanted to talk about. But I just offered that information just because I wanted to make sure I was clear with him.
Did you disclose to him that you were still working as an independent contractor?
I don't believe so. Okay.
And what was the substance of the subsequent telephone conversation after these emails went back and forth?
He basically just wanted to say that they were having a conflict and what was the budget proviso for. And I looked up the language of the budget proviso on my laptop and read it to him. It said, because in there it said that the money was supposed to be split between two separate organizations.
And was there a follow-up conversation or emails with Mr. Stanley?
Yeah, he, on that phone call, I think he said that he was going to get the parties together to have donuts. I don't know if he had already talked to Sharon at that point or not, but I remember him talking about donuts and that he was going to get them together to have donuts in his office. And then he called me back 2 days later and said he did and that everything was fine. And then did you have
follow-up discussions with Sharon and Anthony about this?
Anthony actually texted me afterwards.
I would direct the board's attention to 309, Exhibit F. And that's on the board now. Can you identify that document?
Yeah, it's a text message that Anthony Powers sent to me.
And can you tell us how you interpreted that text message when you received it?
He said that he left that meeting with Chris and Sharon and thought it went great. He went to coffee with Kim afterwards and told her that he'd take care of the amendments with Sharon, and she was cool with that.
Was that consistent with Mr. Powers' testimony here to the board?
No.
Do you believe he was being truthful with you, or do you believe he was being truthful with the board?
I really can't tell anymore.
Okay. Did EEC pay you to talk to Chris Stanley?
No.
Did you receive any benefit from talking to Chris Stanley?
No.
When the contract was amended, did EEC provide you any benefit?
No.
Was there a legislative nexus between your discussion with Chris Stanley and what? Do you regard your discussion with Chris Stanley as something you performed in your legislative role?
Yes.
Okay, I'll leave it at that. I want to draw your attention now to exhibits 330 at 330 and 332. Where is that? Catherine Ostrich. Do you recognize these text messages?
Yes.
And can you tell us about them?
Yes, so there's a text string that's in the notice of hearing that's on the Legislative Ethics Board website. And that text string has been redacted in a way, and I don't know how this happened, but it appears that there's missing text messages between the texts. And this is one of the copies. I don't know if you can pull up the Legislative Ethics Board website, but there's an order setting hearing, and there are text messages between Anthony Powers and I. And if you look at that, you'll see this top one that says, "We invited you in during your time of harm." And you won't see waking up seeing this. Look, Tarra, don't blame me for someone else's actions. You won't see the next one on 332. I understand your feelings, but it isn't cool how you're coming at me either. I'm doing what I'm doing. Either you trust me or you don't, but I've been real. But you will see the next one that says you haven't stopped your employee from causing harm. And so it has made me feel like I don't know how that happened, but it makes me feel that the board is not receiving accurate information, because without the full context or the missing text, how does the board really get to the truth of the matter?
Did you provide the text message string to the board's investigative counsel?
No, I did not.
In the text message string with Anthony, there is a text which Anthony testified he interpreted as a threat from you that if you didn't fire Kim Gordon, that you would take action against him in your legislative capacity. Can we first find that text?
I think it might be. It's in the board's stuff, I think. Yeah. I think it's in the board's. It's in the board's materials. I think it's 22. Yeah, it's 22.
There we are. Exhibit 22, 197 and 198. You're right.
Did you ask me a question?
I haven't.
Okay.
I'm waiting for it to get up. Can you provide your explanation to the board of this text message and what you meant and what you didn't mean?
Yeah, I believe this was in beginning of middle of March. Kim had been disparaging my character for a very long time over, I felt, misinformation around my relationship with Antoine and a conflict of interest, because I had always felt that since Anthony knew of the relationship and he had hiring and firing authority as an executive director, that what I was doing in my personal life with Anthony and donating and him deciding to hire Antoine was not a conflict of interest. But that was in 2024, like January 2024. And then, they returned the donation end of February 2024. So for over a year, Kim had been disparaging me in the community. I had actually written to her board of directors at one time and said, can we please engage in some kind of restorative justice or conflict mediation? Because, and this was like September of 2024. I don't know why she's saying these things over and over, and it's coming back to me. And I think this is when I finally realized that maybe Anthony wasn't being honest. I wanted to believe my friend was an honest person and that he was telling Kim the same things, and I didn't know why she was not aware that Antoine and I had a relationship. I didn't know a lot of things that I've learned recently, but so she had filed this complaint, and it was becoming clear to me that they believed that I influenced Chris Stanley when I didn't. And my friend Anthony is not holding her accountable to stop going around and disparaging me. And I want him to encourage her to get into a restorative conflict resolution and actually have the same information and demystify any biases that she has towards me and actually bring people together to talk. and he's not. And so I'm finally and then he's in my support group though, for leaders they're trying to cancel, which is this support group that I made when I went through the harm I did at Civil Survival. And then he had been terminated from another nonprofit and was coming to that support group. And I finally was not wanting him to come to that support group because I didn't feel like that was I needed that support group for a place of trust. And so I am asking him to not come to this support group, but I'm also telling him that I'm doing what I'm supposed to do, and I'm going to be ethical as a legislator, and that I got the 1815 out of rules when he asked. But that wasn't for him. It was because it's the right thing to do. But I definitely don't feel that you are a trusted friend anymore. So I was trying to draw a line in that I don't want to be your friend anymore right now because I don't trust you. I don't trust that you are being honest. I don't want you to come to the support group. But that I'm still going to do what is right in my legislative role.
Were you asking him to fire Kim Gordon?
No.
Well, you were basically asking for a meeting, correct?
Yes. And I can see how most people would interpret that as firing or discipline, but that's not my values. That's not our values. This whole support group, leaders they're trying to cancel, is about not firing people, not causing more harm to people. It is about mediation and restorative justice. And just like I have advocated for myself here in my role as a legislator to have the HR director offer restorative conversations with my colleagues who I might have conflict with. That is my entire life's goals. When I'm asking to change the systems to make them more restorative and more trauma informed, that is my actual goals in life. And so I try to walk those values in every area of my life. And so no, I was not asking him to fire or discipline her. I was asking him to use his influence to encourage her to actually come into a restorative conversation, because what I find is that in mediation and in restorative conversations, people often learn a lot of things that they don't know about the other person, and they're thinking one way, but then they learn, and we need more of that in our whole world.
And at the end of that message, it says you'd be very hesitant to help you, being Anthony, in the future. I did a lot for you primarily, and then AEJG secondarily. What are you referring to that you did for him?
For him, well, I would also say that there are missing texts in this string that I didn't even realize until a couple of days ago. But what I am saying is that I'm setting a boundary in my personal life. I have given and given and given to my friend, who I thought was my friend. I have given him emotional support, financial support, personal advice. I mean, been there for him when his mother died. I've gone to him for relationship advice, and he is, I've done a lot for him because I wanted to make sure that he had the opportunities that I've had as a formerly incarcerated person. And I was not going to continue to do that anymore.
So in any way, shape, or form, did you mean by that you wouldn't help him as a legislator?
I mean, I will say that I think as a legislator, and the legislators on this board will know, we are responsible to the constituents that we represent in our districts. I would not, I mean, we don't have to take meetings with people who abuse us or call us names or harm us. But we can't impede their access to the legislature or anything like that, but we can have personal boundaries around our own peace and our own self.
So in that last comment, were you speaking in your personal capacity or in your legislative capacity?
I was speaking in my personal capacity.
Okay. Can I have a minute with my witness?
Yes, that's fine. We'll go off the
Okay.
record for a couple minutes. Let us know when you're back ready to proceed.
Let's go outside.
Maybe while we're on, maybe let's just take a
make
5-minute
changes.
break.
And it must do each of them by a set period of time, kind of like an obstacle course. Our legislature is split into two chambers, the Senate and the House. For a bill to become law, the exact same bill in the exact same form needs to pass both chambers in the exact same session. A bill can start in either chamber. It really doesn't matter, just so long as it goes through all those steps. What are those steps? We're going to get into them in detail, but there's only a few key ones you need to keep in mind for now. House bills start in the House. They go all the way through the Policy Committee, the Fiscal Committee. They get voted on the House floor. If they make it that far, guess what? They go over to the other chamber and they do it all over again. The same process. They got to do it twice. Again, why are they doing it twice? Remember what I told you about our system of government being founded by people that were suspicious of government? They wanted to make it difficult to pass a law. This makes it difficult, if nothing else, but it also gives a lot of new sets of eyes on it. A lot of people that didn't see it in the other chamber a chance to look at it and perfect it. Perfect is kind of a term of art. It doesn't necessarily mean make it perfect like we would think of it, but perfect means get it in a proper legal and political compromise form. So it's gone all the way through one chamber, it goes to the next, they do the same thing, and they all have to agree on it. It has to be the same bill, same language voted on by both, and we'll come back to how they accomplish that. But in a nutshell, that's how it works. Policy Committee, Fiscal Committee, floor, go over to the next chamber, they do the same thing, and then if you do all of that, you go to the governor, and the governor can pass it, veto it, or allow it to become law without signature. That's it.
In-depth, unedited interviews with state leaders. That's hard to find these days, but that's exactly what we bring you each week from the TVW studios. Tune in on TV, online, or on podcast for TVW's Inside Olympia.
Well, the fundamental issue in housing in our state is this just severe shortage, and what it leads to is cutthroat competition for a limited resource. Absence of affordable housing leads to increased homelessness. It leads to increased cost, not just to buy a home, but also to rent, because if people can't buy, they stay renting. If they stay renting, occupancies go up. If occupancies go up, then rents go up.
When I first moved out here, I was living in my car. The rent is so expensive out here. I could not believe the prices. And I'm like, my job could not afford it. I can handle it by myself, but my kids have to go through that in the cold, you know, cramped up in the car. I was even searching for regular houses where I can pay rent, but couldn't afford them. So I just kept searching for low-income housing. Finally, I got a call back from this place.
As host of Inside Olympia since 2008, I appreciate the opportunity to conduct in-depth interviews with the state's leaders, from the governor to state legislators to state agency heads and beyond. These are often interviews nobody else is doing, and they are an important contribution to the civic health of Washington State. TVW is Washington's unblinking eye on state government. Its presence strengthens the civic bonds of the state. It ensures both visibility and access to the work of the governor and state lawmakers, but also state agencies, various committees, the courts, and so much more. In an era of declining media, TVW's role in strengthening the civic fabric of the state is even more important.
Now airing on Washington to Washington.
I'm gonna meet Drake next week.
The use of AI chatbots.
That's always gonna agree with you, which I feel like is really a red flag, honestly.
The challenge here with AI chatbots is that they are designed to be sycophants. They are designed for positive, unconditional validation.
And the impacts they're having on young people.
He gets completely lost in this thing. He goes out in July. He tells this thing, I'm in my car with a Glock. When I'm done with these hard ciders, I'm going to shoot myself.
Technologies should serve people.
State lawmakers in Washington and across the country are making AI regulation a top priority.
All of us are on the same train, and we're trying to figure out where it's going in the safest, most responsible manner.
We want to have modernized systems that leverage AI to the point that we can with chatbots and others, but making sure that that data is secured and the public is aware of where that data is coming from.
While in the nation's capital, President Trump looks to limit state regulations and encourage AI innovation.
We need to make sure that we win the innovation race, and we need to make sure that's not getting stymied at the state level.
It's incredibly important that we have uniform federal legislation so that businesses have certainty. But if the legislation is not doing enough to protect people, then states should have the right to develop the legislation that they think they need to protect people.
From the capital of Washington State to the capital of the United States. Watch anytime at tvw.org.
I move that the rules be suspended, that in gross substitute Senate Bill 5121 be advanced to third reading, a second reading considered the third, and the bill be placed on final passage.
One of the confusing things about the legislature is that we use antiquated language.
Mr. McKinley, are you ready to proceed? All right, board staff, ready to proceed?
Yes, Your Honor.
I'm going to call up Exhibit 2, page 32.
All right, we're back on record. We took about a 5-minute break, and you said, Mr. McKinley, Exhibit number 2, page 2?
Page 32.
Page 32, thank you.
Representative Simmons, you had just testified about the context of your text message to Mr. Powers with respect to seeking restorative justice with Kim Gordon. Is this email relevant to that?
Yes, it is.
Could you explain that to the board?
Yeah, so this was in September 11th of 2024. She filed this complaint in the end of February during the AEJG EEC contract dispute, but this was almost, 5 months earlier, where, again, I had heard that she was disparaging my character in the community. And so I sent this email to her and copied Anthony Powers, who is her executive director, her boss, but she's also his boss. But I was trying to find out, and then these other two people on the CC line are also board members that I knew of the organization. And I am wondering, why she is continuously disparaging me. And I know now she doesn't understand that Anthony knew about my relationship with Antoine when he was hired, but I am asking her at the end, I'm asking, if you'd like to engage in some dialogue or allow me to meet with your board, then I would be appreciative. As far as I know, there's only one impacted person working at AEJG, and that's important because people who share these painful lived experiences do not judge and cancel each other. We actually know a different life and give each other due process and communication. We generally live our values of restorative justice and care for each other. And so my point of this was trying to make that behavior stop through compelling a conversation to clear up, bias or dispute their lies.
And your subsequent email to Anthony Powers was a follow-up to your frustration with this communication?
Yes.
Okay, now I'd like to turn the board's attention to 339, and I think this is Exhibit F. And I believe it was both Mr. Powers and Ms. Gordon testified that you had indicated to them that the $40,000 was to be spent only for Antoine and not for other purposes. Is this text message relevant to their testimony?
Objection calls for a legal conclusion.
Mr. McKinley, your response?
I'll withdraw the question and rephrase.
Go ahead.
Can you describe this text message?
Yeah, this is a text message I sent to Anthony after Kim Gordon filed the complaint. Oh, and this was after I finally got some information about what the complaint was even about. So this was probably in the end of July that I sent this text to Anthony. And there was 3 things that Ms. Struess had listed in the email to my prior attorney that were I was being accused of. One was the donation to AEJG and a claim that Antoine was my boyfriend. The second one, if I remember correctly, was the contract dispute. And the third one was my job duties at EEC. And I was responding to Anthony and showed him a screenshot of the email that I got from Ms. Struess and, said, as, ED, it's in your purview to hire and fire. Why would it be my responsibility to go to the board of directors? Because as long as the executive director knows that I'm in a relationship with Antoine, it should be his decision. And he didn't see a conflict, so I didn't feel like it was my responsibility to go to his board of directors, but I didn't even know his board of directors. And he says, yeah, plus it was 2 $10,000 donations, right? One was an uncashed check that was returned. And I said, it was one for $10,000 and the second was for $40,000 to help all of you out for a bit, plus retreat costs, but that was uncashed. So it was just a text exchange with Anthony and I.
At the time that you wrote that text message, did you know that Kim Gordon and Anthony were claiming that you had specified the money only be used for Antoine Coleman?
I did not.
Okay. Finally, the very last page, 362. It's the very last page of the exhibits.
You want me to read it, or?
Can you explain, in your mind, the significance of this email that Anthony sent you in February of 2024?
Yeah, this is during the time where he was expressing to me that he was, concerned about Kim being on his board and being a staff member, and the ways that he was not allowed to lead his organization or make decisions. And he was asking me about my feedback on his proposed budget, and that he'd be raising people who had part-time work and full-time some, but that the organization was very white. He wanted to diversify his staff, is one of the things that he consistently told me through that fall when I was supporting him. And just that he wanted a diverse team. And yeah.
Was this before or after you introduced him to Antoine Coleman?
It was right after, because I introduced them, December 15th is when we had the lunch, and I think they talked and interviewed like the next day. But I think he was just telling me his goals for the organization. He wanted to diversify his staff and hire more people too.
Okay, we rest.
All right, board staff, cross-examination by Assistant Attorney General Eisentraut or Stanifer. You may proceed.
Yes, Your Honor. Our paralegal stepped out, and I know she's helping out with the exhibits, so. Okay, maybe we can have other folks help out. Thanks. All right, I'd like to turn to what's been admitted into evidence as Exhibit F, 280, LES 280. There's a text message that you wrote, I believe, on this page at the top.
Yes.
Okay. Send an email to you at AEJG with my finance person, sending $10K myself to start him, but we'll get your info packet and try raising more now. If not, I will send another donation when you need it to cover him.
Yes.
Okay. So you're indicating there that if the $10,000 isn't enough, you're willing to send more funds to continue to pay Mr. Coleman, correct?
Yes.
Okay.
May I add to that?
No. But your attorney can ask you on redirect.
Okay.
Can we turn now to what's been admitted into evidence as Exhibit C?
Yes.
Thank you. Specifically, I'd like to go to page 5. This is a declaration I believe you prepared, Representative Simmons.
Mm-hmm.
Page 5, which is LEB 197. I'm just waiting for it to show up on the screen here. So item 35, just verifying, when you say I offered to introduce Anthony to a friend who shared many similarities, you're talking about Mr. Coleman there?
Yes.
Okay. And then you write below item 37, Anthony told me he also needed money to hire the additional help. And then finally on item 37, I told Anthony that if he interviewed my friend and found the connection to be what he needed, I would donate the money needed to make the hire.
Yes.
That sounds conditional to me. Would you agree?
Well, they were two.
Mr. Sandifer, your response?
I'm not aware of what legal violation he's referring to, I guess.
I'm not referring to a legal violation, I'm referring to a legal conclusion. A conclusion that it's conditional.
I'll allow that. I'll allow this question because it's asked in a layperson's terms. If this witness knows the answer, she's welcome to answer the question.
Yeah, I was offering to donate for the need if he needed that. If he decided that and he needed the money, I would donate it to him.
For Mr. Coleman?
Yeah, if he had the need, I would donate it to him, yes.
Okay. You mentioned, moving away from this exhibit, you talked about the $40,000 donation that subsequently went to AJG from your campaign surplus funds account. I'm just trying to understand your testimony. Was your testimony that this had nothing to do with Mr. Coleman and had everything to do with a tax situation that AJG was in?
Yeah, Mr. Coleman only made $4,000 a month. And so he started after January 1st, I don't know, maybe January 10th, January 15th. So I had donated $10,000 already. By the time I donated in the mid-February, he had only earned like $4,000. So I donated another $40,000 because they needed that money to pay the IRS, or they had enough to pay the IRS and then they weren't going to have money for the rest of a few months for their regular staff.
So your concern, is it fair to say your concern went beyond the tax situation and also to their employees?
It was for general operating, whatever they needed it for.
So wouldn't that include Mr. Coleman, potentially?
Potentially, but I think he had already had enough because he was only making $4,000 a month and I had just donated $10,000. But whatever they needed, it's fine.
Okay. Can we turn to Exhibit F? And specifically at the bottom, 339. See right here, it was one for $10,000. You're referring to the initial donation, correct?
Yes.
And then the second one was for $40K to help all of you out for a bit, plus retreat costs, but that was uncashed. Did I read that correctly?
Yes.
So when you say all of you, again, wouldn't that include Mr. Coleman potentially?
If that's what they wanted to spend the money on, potentially, yes.
Thank you. Let's turn away from that exhibit now. So I wanted to turn to your conversation with Mr. Stanley on February 24th, 2025. I'm just trying to understand, again, your testimony today. I'd like to look back at one of the exhibits. So if we could look at your declaration in this matter that was submitted earlier. It's found at LEB 197, I believe. Bear with me here. Sorry, I don't have the exhibit number off the top of my head. C, thank you.
You said 137?
Yeah, 197.
Oh, 197,
Yeah.
okay.
So item 28 at the top of the page there, you write, on February 24th, 2025, Chris Stanley emailed me requesting a time to meet about the contract relating to the budget proviso. We had a brief phone call wherein I looked up and then read to Mr. Stanley the final language contained in the budget that was signed into law. Did I read that correctly?
Yes.
Okay. I'm trying to understand the accuracy of that. Am I right that just in reviewing your declaration, that's the only thing you say about this conversation with Mr. Stanley? Am I right about that?
Yes.
Okay, but you've supplemented that today, haven't you, quite considerably?
With the budget proviso being consistent with two organizations receiving money evenly, I believe that is the language in the proviso.
So your testimony today is that you actually went beyond just reading the proviso to Mr. Stanley when you talked to him?
I mean, I believe it's the same. It was the proviso. It says that the money is to be split evenly between two organizations.
Okay. Let's look at a different exhibit. Let's go to exhibit 3. Page 5. So if we look at, I'll wait for you to get there. So page 5 of the exhibit, I believe.
Okay.
Let me make sure we have the right thing here. First, let me just make sure I'm looking at the right thing. This is a letter you wrote to the Legislative Ethics Board.
Mm-hmm.
And then page 5 of the letter, there are some bullet points that relate to this interaction with Mr. Stanley. In the 5th bullet point, you write, on February 24th, 2025, AOC staffer Chris Stanley contacted me, not the other way around, to ask about the historical relationship between the two groups. I voluntarily disclosed my prior work with EEC.
Yes.
Okay. So that's accurate?
Yes.
Okay.
But I didn't have any historical knowledge about the two groups because I didn't know anything about, since I did the proviso, I hadn't received an update at all. So I just read to him the proviso, and my intent was in the proviso that it be split evenly between two groups.
Okay. Let's turn away from that exhibit. Let's go back to one of your respondents' exhibits, F. And specifically at the bottom of the page, 303. So this text message reads, me and Antoine been in Chesapeake Bay, but obviously this BS is on my mind. The only thing I can think of is she's mad because Chris called me to ask what I knew about the proviso. That's my job to tell him. Did I read that correctly?
Yes.
Let me break that down. So are you talking about you and Mr. Coleman being in Chesapeake Bay there?
Yes.
Okay. And when you say BS, this BS is on my mind, are you talking about the complaint that Mr. Gordon filed against you?
Yes.
And when you say she's mad, are you talking about, is the she there, Miss Gordon?
Yes.
Okay. So, it looks like here Mr. Stanley talked to you about the proviso, and you felt like it was your job to talk to him about that.
Yes.
Okay. And what you knew about it.
Yes.
I assume that means including the intent of the proviso?
That it be split evenly between two groups. That is in the language of the proviso, and that was my intent.
Okay. Were you at all worried that if EEC lost their funding, it could potentially jeopardize your relationship with them, your personal relationship?
My personal relationship, no.
Your employment relationship or independent contractor relationship?
I was already on my way out from that. Actually, I ended up leaving March 31st, and they paid me through March 31st.
Why did you separate from them?
They didn't have any more money.
There wasn't another proviso coming?
I don't believe so.
Okay. Let me just ask about something. I just want to clear up. If we could stick with Exhibit F and go to 286 at the bottom of the page. So you write there, did you ever talk to Chris Stanley? He's testifying before me now. That's your text?
To Anthony, yes.
Yeah. And are you talking about that you were sitting in the legislature and he was testifying before you?
Yes.
Okay. And you use, I'm no expert on these emojis, but is that the rolling on the floor laughing emoji?
Yes.
Okay. I'm just trying to understand, or do you view Mr. Stanley as a joke, or what's the joke here? What am I missing?
No, I just am an emoji type of person.
Okay. Let me turn to a different topic. Let me turn to, well, let me ask you, you talked a lot about the text messages between you and Mr. Powers, and your attorney asked you questions about, what your intent was with regard to those text messages. And I believe your testimony was about wanting to have a restorative conversation with Miss Gordon?
Yeah.
Okay. Can we turn to LEB 194? And that is exhibit. Actually, one sec. Give me one moment. I think I have the wrong page there. Just one sec. Sorry, our exhibit, so staff's exhibit 9. Specifically well, it's marked at the bottom, 194.
Mm-hmm.
So at the top, excuse my language, but I'll just say, what an effing crazy, she is wacko. Is that your text?
Yes.
And are you referring to Kim Gordon?
Yes.
Were you in a restorative conversation kind of mood when you wrote this?
Well, this was June 30th, 2024, right? What is the date of this? I think it is June 30th, 2024.
If you go back to, I believe, at the top there, it's marked Sunday 30th, June 30th, 2024. Is that what you're referring to, Representative Simmons? Okay, go ahead.
And she was accusing me of something nefarious. And I can simultaneously believe that somebody is really out there and not thinking properly, and also be willing to enter into a restorative dialogue with them in hopes that they will correct their bias and get into the truth.
Thank you. We can move away from that exhibit. Thank you.
Mm-hmm.
Actually, let me go back and just ask you one brief question about the surplus funds donations.
Okay.
There was a lot of advice that you talked about that you had asked for. You never sought advice from Jennifer Struess concerning your donation of surplus funds specifically to EEC, correct?
To EEC? I've never given surplus funds to EEC.
I'm sorry, to AEJG.
Specifically to AEJG, no. And when I did talk to OHAD about surplus funds, he told me that that's under the jurisdiction of the PDC.
Okay. Let me move then to a different topic. Well, let me just ask you about, sponsoring a proviso for the 2024 proviso specifically. Same question. Did you ask Ms. Struess specifically about the ethical implications of sponsoring that proviso when you were employed by or contracted with EEC?
Not that specific proviso that year, but I had received advice before when I had gotten funding into 5476 that went to my employer, that I was actually paid out of those funds.
Let me talk to you about some of the advice you got, because it came up. So if we turn to Exhibit C, specifically at the bottom of the page, 213. So this is a letter that was discussed, I believe, with you, dated September 25th, 2020, that Ms. Drees wrote to you just after your election?
Yes.
Okay. And on the first page of the exhibit, so the page marked 212 at the bottom, there is a list of 13 items. Jennifer Struess writes, just before that list, in an email to me dated September 16th, 2020, you list the following as your current job duties, and there's 13 items. Do you see those?
Yes.
Okay. There's nothing listed in here about sponsoring provisos that would go back to an organization that you worked for, correct?
I'm sorry, what page are you on? You're on. Oh,
Sure.
this is the list of 13.
Yes.
So we would never be paid to do that. That wouldn't be part of our job description. This is my job description.
Okay. So that wasn't something she advised about, in other words, in this letter, in vis-a-vis this organization.
Objection, who's testifying?
Your response?
I'm asking her for her understanding of the letter and whether Ms. Struess was advising her about a specific topic. I don't think I'm testifying.
I'll overrule the objection. You can ask the question and the witness can answer if she knows the answer.
Do you want me to repeat?
Yes, please.
Did you view this letter as Ms. Struess providing you any advice about whether you could sponsor a proviso in relation to Civil Survival Project?
Yes, I believe that would be under the separation of roles, and that would probably be in 214. And it would be also that we can sponsor bills that have money in them.
What are you pointing to?
Like, okay, if page 214, there's a lot in here. The board held that a legislator is not prohibited from supporting legislation, which the operating budget is a bill, it's a legislation, favored by the legislator's outside employer, or opposing legislation disfavored. There's also the general rule around the employer cannot condition employment or results or pay on the legislator to push or advance employer's legislative agenda. And it's clear in this letter to me that as long as I separate my roles, my employer I can even prime sponsor bills that have millions of dollars that benefit my employer, as long as I separate my roles, and I am not paid to do that. It's not in my job description, and I'm not getting any personal benefit.
I just was getting at the fact that in the list of duties, you don't talk about whether you'd sponsor any provisos.
I would never put that in any job duty. I would never be paid because this is my job duties, right? So we can't be paid. That can't be part of my job to get budget provisos for my outside employment. That's what this list is right here, the 13. So that would never be, and it wasn't in my EEC job duties either, right? So that is absolutely a no-no.
Okay. I have nothing further. Thank you.
You weren't that mean.
Can we just leave that exhibit up?
What, redirect, and what was the?
There was exhibit C, 213.
212.
212?
Yeah.
That's right there. Representative Simmons, that list that's in that letter, those are the list of your job duties at your employment in the private sector. Is that correct?
Yes, and that was before I took things off. This was before I got elected. These were my job duties. And with Ms. Struce's guidance, I started to eliminate some of those things and find other people within my organization that could take those over when I got elected.
Well, just following up on Mr. Sandifer's question, he asked you, I believe, if one of your job duties was to sponsor provisos. Does anybody in the private sector sponsor provisos?
No.
So it would never be in any list of job duties of anybody in the private sector that would sponsor provisos in the Washington State Legislature, correct?
No.
Okay.
That would be a per se violation.
Did you assist me in putting together Exhibit F of our materials that we submitted to the board?
I did.
Have we gone through every page of that exhibit?
No.
We have spared you some misery. If the board were to take the time to read through all of those text messages and exchanges in that exhibit, what would they find?
They would find a lot of inconsistencies of Anthony telling me one thing and then telling the board another thing. They would find that Anthony was also hostile towards Ms. Struce and also hostile towards Kim, and they would probably find a lot of other things, and I would be available if they had any questions about any of that.
Thank you. Nothing further.
All right. Board staff recross within the scope?
No, Your Honor.
All right. Since there's no recross at this point, does board legislative ethics board members have any questions for Representative Simmons? If so, please feel free to ask. Okay. Since there's no further questions, you are excused. As a respondent, you're of course welcome to remain here through the duration, but you are excused as a witness subject to recall, okay?
Thank you.
Thank you very much for your testimony today. Mr. McKinley, does the respondent wish to call another witness? And if so, okay, who's the?
Jennifer Struce.
Okay, all right. Let's go off the record for a few minutes to allow the next witness to set up. Mr. McKinley, understanding that we will conclude it at 5 o'clock, we'll portion out time accordingly, okay?
That's fine.
Okay, board staff, does that make sense as well? Okay.
Caseload forecasts are the foundation for the budget proposals.
The budget starts with the governor's office and the Office of Financial Management, where I was the director. We would put together the governor's proposal, which is required by law to be submitted to the legislature on the 20th of December.
Now, the legislature doesn't have to consider any of that stuff, and they guard their power to write the budget pretty zealously. But there also is that.
All right, we're now back on the record. Mr. McKinley, who do you wish to call as your next witness?
Jennifer Struce.
Okay. Ms. Struce, do you understand that you've been called as a witness in the matter relating to Tarra Simmons?
I do.
All right. Before you begin testifying, do you mind if I place you under oath? All right, so if you could please raise your right hand. And do you swear or affirm that the testimony you're about to give in today's hearing is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, let the record reflect that Jennifer Struce has been sworn in. Now, at this point, you'll be asked questions in direct examination by Respondent's Counsel, Mr. McKinley. After that, you'll be asked questions in cross-examination by board staff. As you've heard from the other witnesses, please answer yes or no, just to make sure I have a clean recording of the hearing, as well as if there's any objections made, please immediately stop testifying so I can hear objections and then rule on it before you attempt to respond. And once again, if you receive a question that you didn't hear, didn't understand, or were confused by, please immediately stop testifying and ask that person to rephrase or restate their question, okay?
Yes.
Okay, and then finally, any questions of me?
No.
Okay, at this point, Mr. McKinley, you can proceed with your direct examination questioning of your witness, Jennifer Struess.
Ms. Struess, Kim Gordon testified that prior to filing the complaint in this matter, she was in communication with you and you were advising her about filing the complaint. Was she telling the truth?
Objection. He's asking her to comment on the veracity of the witness.
Okay. Your response, Mr. McKinley?
The veracity of the witness is always an issue.
Okay.
And if I can respond, that's for the tribunal to decide. That's not for another witness to comment on for the benefit of the tribunal. That's within the purview of the tribunal.
I have a right to impeach a witness with another witness's testimony.
You do, in part, as long as it pertains to a specific statement or observation or commentary, but as for the overall veracity of a witness, no. But if there's a specific statement you have that you wish to question this witness by, you're welcome to ask.
It's a highly specific statement. The statement is, Kim Gordon testified that she was in consultation with Jennifer Struess before she filed the complaint in this matter. Is that true?
Okay. I'll allow the question if this witness knows the answer.
Would you repeat the question?
Kim Gordon testified that she was in consultation with you prior to filing her complaint in this matter. Is that true?
Yes.
Kim Gordon further testified that you instructed her not to include details required in the form. Is that true?
No.
Thank you.
Okay. Cross-examination by board staff?
No, thank you.
All right. Does the Legislative Ethics Board have any questions for Ms. Struess as a witness? If so, you're welcome to ask. Okay. Since there's no further questions, Ms. Struess, thank you very much for your testimony today. You are excused.
Thank you.
All right. Mr. McKinley, do you wish to call another witness?
No.
Okay. So are you now resting the respondent's case? Okay. All right, just one moment. With the respondent, Representative Simmons, now resting her case, let me turn back to board staff. Does board staff wish to present a rebuttal case? If so, who do you wish to call as your witness?
We have no further witnesses.
All right. So the board does not wish to present a rebuttal case. Now at this point, since both parties have had the opportunity to present their respective cases, essentially now we have the opportunity to provide closing arguments. Normally what would happen in this situation, and I'm cognizant of the hour that I'm looking at, it is now 4:33, and have every hope and goal of being out of here by 5 o'clock. I typically give the parties one of 4 options in regard to closing statements. Now, typically, if there's a consensus, then we'll go with that consensus. If we don't, then I order one accordingly. The options for closing statements are as follows. The parties are welcome to provide a closing statement now on the record. And I would essentially give each party upwards of 15 minutes to provide a closing statement. The other option would be to hold off, keep the record open, and hold closing statements in, say, maybe 7 to 10 days from now, based on the scheduling of all of the parties. That would essentially give each of the parties an opportunity to collect their thoughts before they provide closing statements. The third option would be to come up with a date and time in which to submit written closing statements. And then after that, the record would close, and the Legislative Ethics Board would have an opportunity to then, once the record's closed, begin their deliberations. And the fourth option would be to waive closing entirely. I consider that a gutsy call, but it is entirely up to the party's discretion. Respondent Simmons, Mr. McKinley, your thoughts, and then I'll ask board staff the same.
We would prefer to select option 3 and provide our closing in writing.
Okay, thank you very much, Mr. McKinley. Board staff, your thoughts? Sure.
Yeah, I guess board staff would be in agreement with that unless the board had a strong preference itself for a closing argument. We're prepared to give one.
Okay. All right, let's go off the record just for one moment. I'd like to have the Legislative Ethics Board confer to figure out what would be most feasible or their preferred method of closing statements. So let's go off the record for a few minutes and have the Legislative Ethics Board make a final determination on their preference. So we'll go off the record. We'll come back on in just a few minutes.
Wow, this is impressive. We're here on the southern shores of Lake Union at MOHI, the Museum of History and Industry. For many years, this was the Naval Reserve Center and the armory for Navy uses here in Puget Sound country. And if you go up on the 4th floor, you'll see where they trained young sailors to be skippers of the ship because there weren't enough ships to train on, so they used this building as an actual training location. It was the first command of many young sailors. Many museums concentrate on what happened after European settlers or Asian settlers came to the Pacific Northwest. But MOHI really concentrates on the people that were here before that as well. And their Native American stories and the learning experience about Native Americans is excellent here in this facility. Well, you've all heard about the B-17s and the B-29s and all the Boeing manufactured airships during the war, and then the commercial airplanes. But behind me is B-1, Boeing's first aircraft. He wanted to prove to the world that not only could people fly, it could fly commercially. It was an endeavor that would work, and carrying the mail and carrying passengers as well. Innovation that started in Seattle and remains in Seattle today. And look here, this is Slow-Mo 4, Seattle's favorite boat. We all remember, at least if you're my age, you certainly remember that first Gold Cup race in Seattle. She came out from under the bridge and the starting gun went off, and those Detroit guys were flabbergasted. She beat them hands down. Slow-Mo 4 will always be my favorite hydroplane. In some ways, the story of Washington State is also a story about beer. There were breweries in Longview and breweries in Vancouver and breweries in Tacoma and breweries in Seattle. Maybe the two most famous ones are the Olympia Brewery and the Rainier Brewery in Seattle. My great-grandfather was a barrel maker that worked at the Rainier Brewery for many, many years, and the big R on the wall back there brings back lots of fond memories of the enjoyment we had on a Sunday afternoon sitting around the table enjoying a glass of Rainier beer. This facility has virtually millions of artifacts, historic documents, pictures, you name it, that talk about the story of our lives and the people that lived here before us. If you want to learn about Seattle's history and have a great day, come to MOHI and see these wonderful exhibits. It's not just a bunch of dusty old artifacts or relics, but it's about innovation and invention and how to get young people involved in making new decisions that will make our community even better than it is now. When it's all said and done, MOHI, the Museum of History and Industry, here in the South Shores of Lake Union, is one of my very favorite places. The Skagit Valley has to be one of my very favorite places. It's a remarkable location. The wildlife is something remarkable, the snow geese and trumpeter swans and birds of prey, and it's just an amazing place. The special time of year is when the tulips bloom. They've been growing tulips in the valley since about 1909. It's just such a beautiful thing to see. The seed industry really spawned the tulip industry. Vegetable seed and so forth was grown there. Some of the best seed in the world. And then people said, well, let's go with tulips. It's now expanded out. It's become quite an industry and of course, a huge tourist attraction for that area. That valley is so diverse and so rich. No matter what month of the year, it's one of my favorite places. I just love it.
We just went through a very difficult legislative session. We had to make difficult choices to balance our budget. We're going to face another difficult session ahead. The president's tariffs will only make this dire situation worse.
Governor Bob Ferguson and top-ranking Democrats blame tariffs for increasing the cost of living in the state and say Washington could lose more than $2 billion in state revenue by 2029 if they stand.
There is no scenario in which these tariffs are good for Washingtonians. And don't be fooled by the administration. Washington's working families and businesses and the state will bear the cost of these tariffs.
State Republicans in the House and Senate take issue with the focus on tariffs, and like the Linden farmers we interviewed, believe there are greater threats to the state's economy.
Why do you think taxes are more of an economic factor than tariffs, at least for Washington businesses?
Well, I think if you look at scale, it's very important to do that, because the impact of tariffs, I mean, I don't know exactly what that's going to be, but certainly hundreds of millions.
Senator Chris Gildon is the ranking Republican on the Senate Ways and Means Committee.
$9.5 billion in new taxes really dwarfs those hundreds of millions. And that was what was passed last session by the progressives in the state legislature. Historic levels of tax increases that is going to trickle down through the economy, and ultimately the consumer is the one that's going to bear the burden.
Senator Gildon acknowledges tariffs are hurting the state, both at ports in Washington and with businesses that run on reliability.
I think one of the biggest things that concerns me about that is the uncertainty, the lack of clarity. You know, if you are a business and you're trying to plan for the future, you like certainty. You like the ship to be steady. And it seems like the tariff policy is all over the map. Tariffs are on, tariffs are off. That causes a lot of uncertainty within the business community, and I think that really hampers the economy.
State Republicans like Gildon want to focus on both taxes and tariffs.
If the tariffs raise the cost of goods and services, well, guess what? Taxes also raise the cost of goods and services.
At the end of the day, they're both taxes.
Washington State Treasurer Mike Pelliciotti says tariffs are taxes, but there's a difference between state taxes that provide services to residents and federally imposed tariffs.
The states are not seeing any of that revenue, nor are local governments, but we're paying the economic cost associated with it. And, you know, the declining amount of jobs and the costs associated with fewer jobs here in our state and the cost of living that's going to be increasing is not made up for with the revenue being generated by the federal government. And that's where there's just a complete misalignment in terms of the benefit that Washingtonians are going to get from these recklessly imposed tariffs.
It's why Treasurer Pelliciotti says the lawsuit filed by a coalition of states to challenge the tariffs in court is so important.
No one is saying the federal government doesn't have tariff authority. It's in the Constitution that Congress does. What's happened is the president has decided to bypass Congress because he wants to issue tariffs to whomever he wants, whenever he wants, in whatever amount he wants to.
Even if a Supreme Court ruling blocks the president's use of the 1977 Act to impose tariffs, the Trump administration is reviewing other trade acts to keep tariffs a core part of the president's economic agenda. As the state treasurer, what advice would you give to business owners and farmers and those who might be impacted?
That's what I've been saying for months, which is buckle up.
All right, we are now back on the record. It is 4:48. We took a brief recess to discuss what kind of closing statement that the parties would agree to. Mr. McKinley, on behalf of the respondent, had requested a written closing statements. The board staff had proposed written and/or providing an oral statement, closing statement. After the Legislative Ethics Board had a chance in deliberations regarding what means of closing statement, based on the hour, the Legislative Ethics Board is requesting that a closing statement be provided in writing within the next 2 weeks, which would be on or before Tuesday, June 23rd by 5 p.m. That closing statement would include, if the parties would like, to include any proposed findings of fact and conclusions of law. As a part of your closing statement, I do understand that there may be a request for costs and fees, and the parties are welcome to bring those issues forward as a part of their closing statements. At that time, Tuesday, June 23rd by 5 p.m., the deadline for submitting closing briefs, at that point the record would close, meaning with the record then closed, that's when the Legislative Ethics Board would then officially begin their deliberations in this matter. As I have expressed to both Respondents' Council as well as Board Council, they are free to have discussions between now and the close of the record on Tuesday, June 23rd by 5 p.m. If there is a possibility of a resolution between the parties, they are welcome to explore those options and opportunities. If this matter is resolved between the parties, please let me know. If there is not a resolution reached by Tuesday, June 23rd by 5 p.m., the record will close, and the members of this board, the Legislative Ethics Board, will then begin their deliberations and issue a written final decision or final order within 30 days, and that is consistent with RCW 3405, 90 days, or excuse me, within 90 days. Thank you for that correction. I'm used to 30 days. Within 90 days, in accordance with RCW 34.05, .461 subsection 8A. So they would issue a final order within 90 days. Now, when you receive that final order, if you are in agreement with it, that's fine. If you disagree with it and wish to file an appeal called a petition for review, you are welcome to do so. However, I would like to stress that there is a strict 30-day deadline associated with filing such an appeal, consistent with RCW 34.05.542. That appeal or petition for review would need to be filed in either Thurston County Superior Court in the jurisdiction where this hearing was held, or in the jurisdiction where the respondent resides. But please bear that in mind, that there is, if you remember nothing else, there is a strict 30-day deadline associated with filing a petition for review of that final order. Those appeal rights will be included on the very last page of the final order, just before the certificate of service. Hopefully that 30-day deadline will also be bolded and underlined as a part of the appeal rights. Now, in the meantime, once we conclude this hearing here in just a few moments, and before the record closes, I would ask respectfully that the Legislative Ethics Board please not discuss the merits of this case with one another until your official deliberations beginning Tuesday, June 23rd by 5 p.m. I would also ask that members of this Legislative Ethics Board not do any outside or independent research on this matter, and that their deliberations would be confined solely to the evidence and testimony that has been admitted. I will make available the official record, which is the audio recording I look down from time to time. I will make that audio available to the parties as soon as this hearing concludes, and as soon as my computer bears with me that I would be able to download audio hearing day number 2. I would also ask that the board not have any outside conversations until the record is closed, and like I said, until deliberations begin on Tuesday, June 23rd. At that time, once your deliberations begin, I would ask for you to fairly and impartially review all the evidence and testimony that has been admitted in this case, and then apply the law to the facts as you see fit and accordingly, and then issue a final order accordingly. With that in mind, that covers everything I needed to go over as a part of concluding this fact-finding evidentiary hearing. But before I do, let me go around the room here. Mr. McKinley, on behalf of your client, Respondent Representative Simmons, do you have any questions, comments, or concerns?
I have one question, Your Honor.
Sure, go ahead.
In the intervening time period before the board has rendered its full decision, obviously Ms. Simmons is prohibited from talking to any of the board members about the hearing and the issues involved in the hearing. Is she similarly prohibited from talking to them at all about any subjects at all?
The extent of any type of gag order in place would be limited solely to the contents of this hearing. If there is business during the ordinary course of business in which you need to correspond with any members of this Legislative Ethics Board, I would ask that you please not reference or refer to this proceeding until after a final order is issued, okay? All right.
Thank you.
No further questions. Does board staff, AAG, Eisentraut, or Stanifer have any other questions?
No, thank you, Your Honor.
All right. Now, do any of the Legislative Ethics Board members have any questions, comments, or concerns for me before we adjourn? All right. With that, it has been my honor presiding over this matter. Please, I look forward to closing the record on Tuesday, June 23rd by 5 p.m. and for the Legislative Ethics Board members to begin their deliberations and issue a final order accordingly. So for all of you out in the public, thank you very much for your time and attention as well. It is now 4:55 p.m. Tuesday, June 9th, 2026, and we stand adjourned. Thank you very much, everyone, and have a good day.